Ashley and Dave, thank you for being here. We'll turn the time to you in just a few moments. We've got John, hello, Walker, Chris Wayman, Chris Wade. So we welcome all of you here. Please, as we go through this discussion here and presentation, you're welcome to ask questions. Dana will be the presenter. We're going to have Dave and Ash start us here in a moment to discuss some of the local things that are going on with the cities, as well as the things that the government is doing. And what we are looking as far as the state legislature is doing. Ashley and Dave are our part of our lobbyist team. They're very good, and we're very pleased to have them as on our team. And of course, we can't forget about Dana. He's a huge asset to us, and we appreciate him being able to be a part of this. And I just sent out an email about 15 minutes ago that will have Dana's presentation, PDF of his slides, as well as some other documents that Ashley and Dave have provided for us, so you can download those as we get on. Where I'm more than happy to send more information out. I know that Steve Scoggin has some great resources on the very thing that the government has just passed, and I will send those links, and I think there's some presentations on regarding that as well. So we're starting to get a lot of information, and we'll pass that on to you. So let's go ahead and get started. We welcome all of you here. This is going to be recorded, so you can refer back to this on our YouTube channel. We appreciate your support, and we just hope that we can help support you as you navigate these challenging times that we have right now. As I mentioned before, excuse me for just a second. As I mentioned before, we have Dave Spatafor and Ashley Spatafor, part of the Capstone Strategies, our lobbyists. They have been a great resource and will continue to be. They're monitoring all the information that we're getting from the different government entities, and they will present here in just a moment. And then Dana will be presenting, and his slides are available. I sent out an email just about 15 minutes ago that have links to his presentation, as well as documents that we've received from the Salt Lake County Health Department and the Summit County Health Department, as well as other resources that are coming out. So this is very fluid, and we'll continue to send out what we have for all of you. It will help if all of you will continue to keep your mics on mute, so that everybody can, and then when you have question, you can unmute your mic and ask any questions that you might have. So we've got a large group of people on this. So we'll turn the time to Dave and Ashley. We welcome you here, and thank you very much for being a part of this. And Dave, Ashley, I don't know who's going to go first, but we'll turn it to you.
Good morning, Dave, and everyone who's on the video call. Ashley is here, and so is Billy Hesterman. I think Billy just joined as well too.
Excellent. Welcome, Billy.
Kate is on another conference call that begins in 10 minutes on critical infrastructure. that we're dividing and conquering today. So you have the three of us, and then Kate's on another call, and I may join that call when we're done here. But anyway, we want to make sure that we provide whatever information that we have. And so maybe the thing to do is, why don't we talk about a couple of things, and then I think most importantly, we can answer any question that arises. Is that okay, Dave?
That sounds great.
As you indicated as folks were joining the call, Dave, all of our time has been, most of our time has been situated at trying to figure out what's happening with all the governments and what's happening with COVID-19. And so we're actively following all to make sure that you and everybody else, everyone else on the call knows what's happening. So basically, where we are right now is Salt Lake County has put an essential, only essential folks can go to work, and construction is kind of in the middle, where some could be essential and some may not. But I think Ashley sent out to you, Dave, that you put on your website, information about what contractors are supposed to do. Isn't that right, Ashley?
Yeah.
Make sure I'm off mute. So actually, it's silent on construction. So it does say suggested essential services only, but then it says all other businesses not closed or deemed essentials are required, to exclude employees with a fever, respiratory system from working, and required to practice social distancing. And then the second document that I sent was a guideline for construction services and how contractors should operate. Again, this is only Salt Lake County, but we've heard that, I don't know how this differentiates from Summit County. And then we've heard that Davis County might be doing something similar. And from the conversations that we've been on, we've hoped and we ask that a lot of these counties at least do similar things, so you can at least work seamlessly between, city to city to county. So I won't go through the entire thing of what the construction guidelines say, but I would, suffice it to say, this is probably the way that you should, the best way to stay in business and to stay in business, safely and healthily. So.
I think the key things there would be make sure all your employees don't share tools. They they wash their hands periodically. They've got their covers for their shoes, those sorts of things.
Don't share water bottles or don't have a common water cooler. Do not share, personal protection.
Yeah.
It's all pretty common sense, but I think it's something that should be posted on sites, that should be, very clear as you guys continue to work, if you are continuing to work.
One point I want to make. Let me just add one point before you go, Dave. Last week in Summit County, there was an example on a work site of what not to do. One employee went to work and he wasn't feeling well, and the other employees were razzing him about coming to work and being sick. Well, he immediately started to cough on everybody because he got ticked off at everyone. And that was a situation that became untenable. And that's one of the reasons. There are a lot of reasons why Summit County shut down, but we need to, as management, we need to make sure we manage our employees and manage the construction site, whether it's a repair, whether it's new construction, whatever the case may be. I think if for us to stay in business right now, we need to make sure that we bend over backwards to do whatever we can to protect our employees' health and the health of the folks that we're working with.
Very good. And I just want to, again, reiterate the fact that I've sent those documents via an email this morning to all the association members, link to those documents.
I think maybe one thing to also jump on is, if you want to talk about the small business paycheck protection program, I think Dana goes into that. But the other thing that we are doing is we're coordinating with the cities, Utah League of Cities and Towns. As you know, Kate's also a council member at Bountiful. We want to make sure that that the processes to continue working are still in place. And so far, what we've heard is cities are still open for business. So whether that means inspections, whether that means plan checks, all of those things. I think some of the cities are kind of trying to be a little bit more innovative to make sure that everybody does it safely. But what we've heard is the cities are still open for business, that are all by law and that they're allowed to do. So if you have any issues with any particular cities or any things that you come in contact with, you have any issues, please let us know, because we're in constant contact with the league and with various cities.
As in this, Ashley just mentioned Payroll Protection Act at the federal level, and Dana might go into that, but let me just say a couple of things. As employers, if we've let employees go, or if we're worried about that, I would encourage everyone to file on the Payroll Protection Act. It's part of the congressional bill that passed last week, the $2.2 trillion bill. $350 million, no, $500 million, $500 billion is set aside for small business. And essentially, if you're losing employees and you want to continue to pay them, then you're eligible to get 2.5 times your monthly payroll. And you have to keep, and if you get any money, you have to keep all your employees on the payroll for the months for the next 2 months. And that's absolutely critical, because if you do that, then that gives you 2 months of payroll and a half a month to help with your overhead. And if you do that, then the loan is forgiven. If you don't do that, then you'll have to repay the loan back. And I just got an email from my bank a second ago. They are on a phone call this morning at 11 o'clock. And so this afternoon, at least the bank that I bank with, we'll have all the paperwork ready to go to process the loans. And so the recommendation is if you're going to lay people off and you want to keep them on, this is a good thing. And I would recommend you work with your banker. You don't work with SBA, you work with your banker. Looks like Dave had to step out of the office. At this point, does anyone have any questions for Ashley or Billy or me?
Maybe one more thing just to throw in there. We do know that there will be one or more special sessions throughout the interim where the state will adjust their budgets or set aside additional monies for different programs, things. We don't know exactly what that includes. If that's going to be additional, help for small businesses, if it's for additional healthcare costs or things like eviction moratoriums and things like that. So there's a handful of things that the state legislature will be dealing with throughout the interim. We've heard that the first meeting could be as early as middle of April. So we'll be following that as well.
Thank you, Ashley. I'm glad you remembered that, because I forgot. I read the other day and talking to folks in the governor's office, expect one special session in April, probably the week of the 13th, the third week. What the state wanted to do is they wanted to see how that $2.2 trillion federal package would affect Utah. And we're probably going to get what, Ashley, about $1.5 billion.
Between 1.2 and 1.5 billion is the guesstimated amount of money that each state of Utah will.
And the legislature will deal with that. The other thing that they'll deal with is they're going to have to adjust their budget. Now, a couple of things are interesting. First of all, they pay $800 million a year on construction projects that they pay out of their general fund and not bond with. So that's money that they can utilize to the general fund. The next thing they have is $900 million in rainy day funds, so they can utilize that. This last session, they appropriated money to do 4 or 5 building projects. Those are probably going to be put on hold. So if you were looking at trying to participate as a subcontractor in any of those building projects, that may affect your plan for the next 90 days, because I think those projects are going to go on hold. Excuse me. But the bottom line is we'll see a special session in April, and I wouldn't be surprised that we see one a month for the next little while. I'll stop there. Billy, do you have anything you want to add? Okay. With that, any questions from anybody on the call? We've answered all your questions, or have we depressed everybody? The key thing is, and we'll conclude and turn it over to Dana. We will keep working with all local governments to make sure business is open. And so we'll keep working on that. Anything changes, we'll let Dave know. But our request to all of you is, if you have business, if you have projects that you're working on, whether they're repairs, whether they're new construction, whatever the case may be, practice safe distancing. Make sure your employees, if they're sick, don't have them come to work. Make sure that everyone is working on safe socialing. Don't share water bottles. Make sure everybody has their own tools. And the better we follow these guidelines, the longer that government will allow us to stay open for business. If there's nothing else, Dana, are you on the line?
Yeah, I'm here.
Perfect. Why don't Ashley and and Billy will drop off, and then if anybody has any questions for us as time moves on, get them to Dave. He'll get it to us, and then we'll get back with you. And so, Dana, why don't you take it from here? And everybody, thank you very much, and appreciate your accommodations during this difficult time.
That's great. Thanks, Dave. Appreciate that, and Ashley for all the help and all the information. What's going on at the state and the national level. One thing to add on those on the emergency funding to small businesses is that the legislation creates 3 different types of programs. And so if you have an existing relationship with the Small Business Administration, they have an expedited loan process that you can go through because essentially you're pre-qualified. If you don't have an existing SBA relationship, then it's going to be a bit of a longer process, which they recognize. And so within this legislation, they've authorized what they refer to as SBA Express Disaster Bridge Loans. And so you can get funding from that within 3 days while you wait for your broader approval to go through. And so the comment that Dave Spatafor made about working with your lender, that would be your first point of contact. And because the legislation has just passed and the SBA folks at different lending institutions are trying to get their heads around exactly what they're doing, they're getting up to speed on that today. So the first thing to do would be to contact your lender and confirm whether they've got an SBA program in place at that institution. And if not, then you can get on the SBA's website or contact the local office and they can give you a list of SBA lenders. But all the major banks in the state do that. So unless you're banking with a really small community bank, you probably don't have anything to worry about as far as whether or not your bank would be able to help you with an SBA loan. I've got Chris Wade on here with me from our office, and we're going to take some time to go over some of the impacts that we want to talk about. And the direction that we're going to take on this is twofold. What happens if you're not able to get work done because you don't have enough manpower or materials, and then also some things to do if a particular project gets suspended or terminated or something like that. So the first thing you see here on your screen is the recommendations that we're giving at this point. So, and then as we go through our discussion, you'll see where these recommendations fit in, and we'll try to make sure and remind you that as we go through. But the first one is to closely monitor government impacts on the industry and your projects. So, you know, that's these shelter-in-place orders that are being handed down. The industry has sent letters to the governor and has been in communication with the League of Cities and Towns, talking about how construction is essential and we need to be able to continue to work on construction projects. And so the governor on Friday, he did not want to go as far as a statewide shelter in place like some of the other states have. He's left it up to the individual cities and counties. And so far it's been Salt Lake City and Summit County. In Summit County, they specifically say that plumbing and electrical are essential, and so there's an exception on those. So under the Summit County order, plumbing and electrical work can be done. If you have people that go out to do service work, just make sure your service guys understand that they just need to be careful with their, you know, with this, their cleanliness and stuff like that, because different people could be alarmed in different ways. And then on the work site, I'll show you some stuff on work site protocols and stuff like that here in a minute. But we're working to try and understand, as these different decisions get made by different government bodies, exactly what they're allowing and what they're not. And in Nevada, there's a shelter-in-place order, but construction is an exception on that one. Same with California. So in most places, construction is being allowed to proceed. The next one is to obtain written verification from suppliers concerning open subcontracts and purchase orders. So here, what we're talking about is making sure that if you've got projects that are going on right now, that you're going to be able to get the materials that you need, the quantities that you need at the prices you expected when you entered into the contract. So in order to make sure that you don't get surprised, go and just confirm with projects underway that you're going to get what you need at the price you're going to need it. And then also, if you're bidding on jobs right now, or if you've been awarded but you're not under contract yet, get written verification from your suppliers on that stuff too, just so that you know. The next one is this. If you encounter problems, then with your attorney, review your contracts for force majeure, delays, change clauses, claims, suspension, termination, and other parts of the contract that may be able to give you some relief. I mean, obviously, if you run into a problem, the first thing to do, and this is part of the reason for obtaining written verification from suppliers, the first thing you want to do is just let people know as soon as possible if a problem is going to come up so that it could be dealt with. Hopefully, we're going to have general contractors and owners who are going to be accommodating and understand that situations are beyond your control. But within your contracts and even outside of contracts, there are some general legal principles that we could go back to and look at to see if you find yourself in a difficult situation, there's something there that's going to give you some relief. The next one is to make sure that you check your contracts so that you understand what your notification requirements are. If you do encounter a problem with materials, if you do encounter a problem with your workforce that's going to cause you to delay or whatnot, that you know when you have to give notice and who you have to give notice to so that you can do that. Next is if your work is impacted by what's going on right now, whether because you've got people who are sick or there's a city or a county or a state issues an order and you're not able to proceed, track all of those things so that you've got some documentation of it especially. And then the last one, which we'll talk about at the end, is to review your insurance policies to see whether they cover business interruption. And if so, then you need to look at those, go over those with your agent and understand the scope of the coverage and what it will apply to and what notice you may have to give to your insurance company in order to make sure that that coverage remains in place and you've got it in case you need it. Oops. So the next thing is that on these slides is there are hyperlinks on each of these terms to different resources you can get. This first one is Utah's page. You can get current information in there about what's going on in the state. Then you've got national and global databases that we gave you. We've got a link to Department of Workforce Services and all the information that they have available to you to be able to get information on different details about what to do with employees, how to keep work sites clean, different protocols and whatnot. We've got a page up on our website to try and have current information about what's happening in different states, and then the other resources like this. OSHA has put out a guidebook. I'll talk about that in a minute in a little bit more detail. And then National Electrical Contractors Association has a lot of good stuff on their website for not just current information, but also things to be able to do within your business to help address some of the concerns that are coming up. All right, so what you see in front of you right now is this is from NASA. So this is nitrous oxide in the atmosphere, and nitrous oxide is a byproduct of fuel emissions or combustion. So when you see the yellow over on the left, that's cars, that's factories, so it's combustion of any sort. And so that shows, that's from January 1st to January 20th of this year, showing a lot of traffic, a lot of industrial activity in China. And then we jump over to February 10th through the 25th, and you can see that there's substantially less. In fact, that orange dot over to the right, on the right picture, is actually South Korea. And South Korea was substantially more productive than most parts of China in February. And so this is the source of the problem for two reasons. Number one is that we know that the virus came from China, but the other thing that we know is that China accounts for 30% of the building products imported into the United States. And so what you see on the left of this page is, I pulled this morning from the state's website. This is current counts. So these are positive tests of people with coronavirus in the state. And the upward trend that you see is the reason for the governor's order on Friday. To the right is just what I read to you, which is the fact that 30% of materials come from China. And so China being the source of the problem, whereas the virus is that's creating an impact on the labor force. And that's with the government activity, the shutdowns and things like that. And then also if you've got sick employees. And then since China accounts for 30% of the materials imported into the United States, and we see that China has been slowing down its industrial output, then that could create some material problems. So the purpose of what we're going to talk about here is not to scare everybody into thinking that everyone's going to get sick or that there aren't going to be any materials, but just to point out that there are potential problems out there. And so we want to make sure and give you information to get ahead of the problems as much as possible. So labor impacts obviously are the health of your employees and the health of their families. If they're sick, if their family members are sick, or if you've got these shelter-in-place orders, which we're now starting to see in Utah, which were previously just in place in other states, that's going to impact your productivity and your ability to keep a job on schedule. The other thing is that the bottom bullet there where it says workplace safety, OSHA's general duty clause requires you as an employer to provide your employees with a work site that is free from recognized hazards that are causing or likely to cause death or serious physical harm. And so you've actually got a legal obligation to provide that type of a workplace for your employees. And that's the reason for the OSHA guidebook and the link to that guidebook. But I'll show you the main parts of that as it affects construction here in a second. The other thing I want to touch on here, if we go back up to the first bullet point under health of employees and families, is underneath it, the middle one that says loss of labor for employees caring for their families. So with the first act that passed last week from the Senate, finally, you've got an expansion of the Family Medical Leave Act and expansion of paid time off work for employers of less than 500 people. And so if in the past you've had a business policy where you don't pay people for sick leave, or you've been an employer of less than 50 people, and so the Family Medical Leave Act has not applied to you, that's not necessarily the case underneath these laws that have come out for response to this. And so you may have situations where you have employees who legally, despite existing company policies, have to be given time off work to care for or help other people and their families. I briefly talked about this, so let's jump down to the Nevada one because I want you to pay particular attention to this. So what Nevada did is they issued a shelter-in-place order. The state did, but then they made construction an exception, so construction can continue to proceed in Nevada. And then what they did is they dove into that OSHA guidebook, and they put out these rules for what they want to see people doing on their job sites. And so that's these bullet points down here under construction exempt, but the contractor must restrict meetings, safety meetings, tailgate talks, and other gatherings to no more than 10 people. That's out of the OSHA guidebook. Establish effective social distancing protocols, which ensure that staff maintain 6-foot personal separation from other staff during discussions where 10 or less people are present. Ensure that social distancing protocols are maintained during operation of mobile service equipment designed for 2 or more passengers, including but not limited to man lifts, scissor lifts, etc. Then the next one, provide sanitation and cleaning supplies for addressing common surfaces and multiple user mobile equipment or multiple user tooling. That goes back to Dave Spatafor's comment that to the extent possible, have your people use their own tools, but also just make sure they're wearing gloves, and it's cold enough, I suppose most people are, as often as they can, except when you just something small enough that you can't use your gloves. But people having their own tools is good. The next one, maintain 6-foot separation in labor transportation, such as buses, vans, etc. So that's if you've got guys meeting together and driving to a work site, trying to be careful. I realize that it's pretty hard to keep 6-foot separation in a truck or in a van, but you do what you can in the best way that you can. Conduct daily surveys of changes to staff and labor health conditions. So at your office and then also out on your job sites, have your foreman or superintendent knowing what sort of a condition people are in when they show up for work and how they're doing throughout the day. And then make sure first responders have personal protective equipment and other equipment to protect them from communicable or infectious diseases. The idea there is that if they do have to help somebody, if they have to do compressions on someone or something like that, that they would have appropriate equipment to be able to do it. And then last is give them access to potable and sanitary water. And that again is people are bringing their own water on the job, make sure that they're not sharing and stuff like that. So like I mentioned, as an employer, you've got this general duty here to provide a safe workplace. OSHA, I'm going to jump up a couple more here. This OSHA guidebook, that's the 5th bullet point under our resources, has come in to give you information to look at to be able to fulfill that duty to provide a safe workplace. And then Nevada has taken that workbook. If I gave you the citations for these bullet points in here, all of them except the last 2 are cited directly to that OSHA guidebook. And so what you've got here is sort of the essence of what OSHA says to do on construction projects. And I think if people are conscientious of what they're doing while they're working, then this is not a huge burden on people who are out on the job site. Okay, so this is one of the Family First Coronavirus Response Act. This is the one that was supposed to pass the Senate, that was all set to go in the Senate, and then Pelosi got back to Washington and stalled everything and delayed it for a week. This law applies to furnishing employees with sick leave and the expansion of the Family Medical Leave Act as it applies to coronavirus. The stuff that we were talking about with the Small Business Administration, that's separate. This just deals with paid leave and expansion of family and medical leave. So it affects every employer with less than 500 people. It's actually effective April 1st. The law said that it would go into effect no later than April 2nd. The U.S. Department of Labor got their rules put together and said they will be ready to go on April 1st. So that's Wednesday. And then it expires on December 31st. In fact, the hope is that it won't be necessary well before December 31st, but it will cease to be law on December 31st unless Congress does something with it. You are required to post a notice about employees' rights under this law, where they can see it, just as you have, just like the other job notices that employers are required to post, like in break rooms or things like that. You're required to post this. So I don't think that means that you have to go out on the job site and post it, but somewhere in your place of business, you need to put it up wherever you put all of your other notices about employee rights. If you have less than 50 employees, it is possible to get an exemption. And if compliance with the law is going to prohibit your business to be viable, then you can ask the Department of Labor for an exemption. And the part of the thought is that since we've got these SBA loans that have been approved now, that that having the money to pay people not to work, which is one of the things that this law requires, should not be a problem. And so assuming you're able to qualify for one of those loans, if your business is basically shut down because people are on sick leave or taking Family Medical Act leave, you should be able to get money from the government. So they're probably going to be looking at something different than just your ability to fund. But if you've got fewer than 50 employees, just know that that exemption's there, and we'll see exactly how they're trying to put that together. They're going to have more details on that. Let's see here. Nobody here has signed on to a collective bargaining agreement as far as I know, but if you are a company that's got union labor, and if they have a multi-employer plan that pays for sick leave and paid family medical leave, then that's going to take care of your obligation under this. Okay, so like I said, there are two parts of this law. There's the paid sick leave, and then there's the Family Medical Act part. So this slide is on paid sick leave. So the cap here is 80 hours. 80 hours of paid time off for these sick leave qualifications of your employees. And they have to fall within one of these criteria. So it's not just a general ability for someone to take sick leave and get paid for sick leave, but they have to meet these criteria. So the first and foremost is that somebody has to be symptomatic. So they have to be experiencing symptoms, and they have to be seeking medical diagnosis. If they've just got symptoms, but they're not seeking a diagnosis, then they don't qualify for paid sick leave. They don't qualify to get this up to 80 hours of paid sick leave. So if somebody's just not feeling good and they take a day off, they fall under your regular policy, whatever your regular policy is. But if they've got the symptoms, you know, if they've got fever, runny nose, shortness of breath, those types of things, and they're going to go and they're going to get diagnosed to see if they've got it, then for that time that they're off to do that, have those symptoms and seek that diagnosis, then starting on Wednesday, they qualify for paid sick leave. And so you have to pay them 100% of their wage for a maximum of $511 a day, or $5,110, because the idea there is that you've got 2 5-day work weeks, so that's 10 days. So 10 times 511 is the 5,110. Okay, so that's criteria number 1. Criteria number 2. If they can't go to work, so regardless of whether they're symptomatic or not, because the government or their doctor has required them to quarantine, then they get 2 weeks of paid leave at 100% of their rate, their regular rate, maximum $511 per day. The next is if you've got someone who is assisting someone who's quarantined or symptomatic. So this is the idea of, you know, a mother with kids or with parents or family members or things like that who are sick. If your employee does not fit the criteria for the first two, but they're assisting someone who does fit one of these 2 criteria, then they can request paid leave, but here it's 2/3 of their rate with a $200 cap, $2,000 max. And the next one, same sort of a thing. Again, you have an employee that's not symptomatic, not seeking medical diagnosis. They themselves are not quarantined, but they have a child who can't go to school because the school's closed, or who can't go to daycare because their daycare provider has shut down. Then it's the same thing, 2/3 of their regular rate, $200 cap. And then the last one is sort of the catch-all. So if someone is experiencing any other substantially similar condition specified by the Secretary of Health and Human Services, then they get 2/3 pay. So these are the situations under which you've got an obligation to pay somebody who's not working at your office, on a job site, and so forth. The 80 hours is a max. So it's not like if you pay every 2 weeks, they can get 80 hours within a pay period. There is a total of 80 hours. Like I said, it starts on April 1st. If you have a policy right now where you don't pay people if they're sick, and you have people who are off right now because they're sick, they don't get this money. If on April 1st, they continue to be off work because they're sick, then starting on April 1st, they would qualify for pay. But it's not retroactive. It doesn't look back for application. And once they've been off work and they've been paid for 80 hours, then that's it. The obligation's been fulfilled. It doesn't begin again. Okay, now that's paid sick leave. Here's the next part, which is the Emergency Family Medical Leave Act extension. So what you have now is that someone can get up to 12 weeks of leave under the Family Medical Leave Act. So the first 10 days are exempt. So their first 10 work days, this act doesn't apply at all. The reason is that this pretty much covers whatever could happen under here, is the idea. So they could pretty well get the coverage based upon what's here with the time off for emergency paid sick leave. But after the first 2 weeks, for the 10 weeks following, then they're paid at 2/3 of their rate. And here it's a $10,000 cap because of the time period under the Family Medical Leave Act. So what this applies to is not if the employee can't work because they're sick. This allows an employee time off to care for a child if they can't go to school or daycare and the employee can't work or can't work from home. So they have to meet both of these criteria. So this is a child care focused deal. And you don't have to furnish it to anyone who's been working for you for less than 30 days. Another thing that is new with this act is tax credits. So the way the tax credits work, and this is intended to be a way to help fund this as an employer without the loans that we were talking about. So what you do is you take any of the money that you pay to your employees for sick leave, or so this money that you pay here on any of these criteria, or that you pay here if someone's taking care of their kids, you take that and you add it up for the quarter when you're going to pay the employer's share of Social Security to the federal government. So if you do your payroll in-house, or if you have a payroll service, then even though you do payroll tax withholdings every paycheck, you pay the federal government on a quarterly basis. So when you get to that time where you're at the end of the quarter and you need to pay the federal government the Social Security portion of payroll taxes, then you add up any money that you paid to your employees for emergency sick leave, any money that you paid to your employees for this expanded family medical leave stuff because they're taking care of kids, and you deduct that from what you have to pay to the Social Security Administration. So if your quarterly deposit to the Social Security Administration for the employer's share of Social Security, so that's 6.2%, if that adds up to, for all of your employees, let's say $20,000, so your deposit to Social Security is going to be $20,000, but you've paid in that same quarter $10,000 of sick leave or Family Medical Leave Act, then you deduct that $10,000 from the $20,000 that you owe to the Social Security Administration, and that leaves a $10,000 balance. And so then you pay that $10,000 to the Social Security Administration. So the idea, so you credit what you pay your employees against your Social Security tax, the employer's share of Social Security tax. You still you still deposit the employee's portion that you've withheld, but on your side as the employer, you get a credit against that. Now, if we take the same situation, but let's say that instead of having paid your employees $10,000, that between sick leave and Family Medical Leave Act, you've paid them $30,000. So now you've actually paid more than the $20,000 that you needed to deposit. That becomes a credit to you. So now you don't pay anything for the employer share. The employer share of Social Security for the quarter is zero. And in fact, you've exceeded it by $10,000. So then what you do is you apply for a refund from the Social Security Administration, and you get that extra $10,000 back from the Social Security Administration. And it's not a loan, it's considered to be a refund. So it's just money that comes straight to you. And that compensates you for the money that you spent on employees out taking care of their kids, or if they were sick and things like that. That's how this is structured and how it's intended, so that the money that you pay out to your employees in wages does not create an undue financial burden to you as an employer. So any questions about that? Let's hold here for a second. And if you've got questions about what I've talked about so far with labor and with this Family First Coronavirus Response Act, go ahead and speak up, and I'll be happy to answer those.
Dana, this is Jeff Ty.
Yeah.
Hey, the tax credits apply only to paid leave and or FMLA extension. The Payroll Protection Act is funded through the SBA loans. Is that how that works?
The Payroll Protection Act that we talked about earlier is the SBA loan program. These tax credits I'm talking about here are part of this, what they call the Family First Coronavirus Response Act.
Okay, I had read somewhere where insurance premiums are included in one or the other of these. Are you going to address that? If you have to continue to pay your employees insurance premiums for their health insurance, that can be reimbursed also under one of these.
I don't know the answer to that one for sure. I'm inclined to believe that's the SBA program, because under this one, the obligation for what you're required to pay is only discussed as far as their regular rate, and so it's wage based. So I think this is just wages, and that you would get any benefits through the SBA based program. But I will check on that. I will check and make sure, and I'll give Dave the information so that he can get it out to everybody.
All right, thank you.
Thanks, Dana.
Yeah, and then there's in the chat, there's a post that said they have to pay Social Security taxes every payroll, so it's not a quarterly payment. Then what that means is that the application for payment is at the end of each quarter of your fiscal year. So if you're paying each payroll, then you would apply for the I'm gonna have to check it. I know they're assuming quarterly. I'll look and see what it says about the other one, and if they're going to give you a credit, if you can credit it each time you make payroll, if you make the deposit. So I'll find out for sure on that and get an answer. Any other questions? Okay. All right. So we talked about potential labor impacts. Let's talk about materials. As I said before, and this is the reason for our recommendation that you contact your suppliers right now on your current projects. if you're going to find out now so that you can get ahead, whether your suppliers are going to be able to have material available at the prices that they quoted to you when you took these projects. And you're going to do that because you want to know if you're going to have it, and if you're not going to have it, then you've got notice requirements under your subcontract, and so it's better to find out now than later, at the time when you could look at potentially other sources, substituting something, stuff like that. Then you've got projects that are bidding. You're going to want to check and know that if you bid now and you get awarded the contract, are you going to have the stuff then? And then if you've got contracts that you haven't started but that you've been awarded, then you need to know that you're going to have it. So you just got to go out and find out from your suppliers what they're hearing, what they're seeing, and what's going on, and whether you could have some potential disruptions because it's coming in from an international source, or because it's a domestic source, domestically manufactured, but it comes from a state where a shelter-in-place order or what have you is impacting the productivity of a given manufacturer or manufacturers. So get that stuff sorted out. In fact, my guess is that a lot of you guys have probably gone and done that. All right, what I'm going to do now is Chris is going to jump in, and he's going to go through some of these things in contracts. So like I mentioned before, if you're aware of a problem that's going to impact your productivity and your ability to keep a job on schedule, as you all know, and I know that as you do, the first thing you do is you start talking to the general contractor and the owner and letting people know and try to get things worked out on your own. But if you run into problems there, then obviously it's important to know legally what rights do you have, and within your contracts, what sort of things could be available to you to be able to assist you in those types of situations. So Chris, if you want to go ahead here for a minute.
Sure. Thanks, Dana. Can you hear me okay?
Yeah.
Okay. I know this giving everyone a lot of information, so I'll kind of try to be brief here. But yeah, we want to talk about a few legal problems and solutions that might come up. So some of the contractual solutions for subcontractors, force majeure is a contractual principle. It's interpreted narrowly by courts. And so the idea is that there's a force majeure means there's a superior force. So something unanticipated that the parties can't control that influences performance under the contract. It's going to be interpreted based on what your specific contract provision says, so it's important to review those. I don't think we see very often that contractual provisions mention a pandemic or anything like that specifically. So usually there will be more general language, or it might say something like other causes outside the party's control. But depending on how specifically your contract defines this principle, you may or may not have access to some of the common law legal doctrines that we'll talk about in just a minute. So if there is a force majeure provision, it's important to figure out what that says specifically, and in that way you can kind of determine whether the events that are happening can give you the option of having additional time under the contract. And as the slide says, you may get additional time, but typically you won't get compensation for delays. And one of the other important things to think about is with these force majeure clauses, you'll have a duty to mitigate. So whatever the issue is, if there's work is shut down in your jurisdiction, so you can't do any construction, or if it's not shut down like it is most places, but if your employees are sick, so your manpower is impacted or the supply chain is impacted, you need to fulfill your duties to mitigate damages by either looking at other suppliers or other products that might be able to be substituted for whatever you're using, or possibly considering, manpower issues, getting other people on the job if your employees aren't able to show up for work. So taking advantage of those clauses could be important depending on what your contract says and what the facts of your situation are. And one of the other important things to keep in mind is a lot of these force majeure clauses have a notice provision where you'll need to provide notice in order to take advantage of the provision. And you'll need to be as specific as you can in those notices with what exactly is causing the problem, steps you've taken to mitigate, how long you anticipate the problem going on, or how long you anticipate the delay going for. And like Dana mentioned before, these are some of the issues you'll kind of want to try to keep in contact with some of the other parties involved in the project, so hopefully you can work things out. But the more you can document your efforts to comply with your contractual provisions and as far as notice and mitigation, then the better off you'll be if you have a legal dispute down the road. Change orders as well, it's important to stay on top of those and be specific in those as to what's causing the delay or the damages. And then the next slide, some of the contractual problems you might encounter as a subcontractor. Suspension of work could be one of those, and again, this could depend on what exactly your contract says, whether the owner general can just suspend work, and what your remedies will be if they do. Again, often they can suspend it for time, but there may not be a compensation element to that. There are also termination for convenience clauses and contracts that you'll need to pay attention to. Typically, they'll require payment for work completed, but they may not include some of your other costs, demobilization, remobilization, storage costs, those type of things. So again, it can be good to kind of keep in mind as you're making decisions on projects of where to store things, or what type of mobilization costs you might encounter if a project gets shut down. And then in addition to some of these contractual provisions, again, if your contract doesn't specifically have a force majeure clause or something like it, then you can have access to some of these other common law legal doctrines. Impossibility is one of these, where generally it needs to be impossible to do the work required, and usually this is focused more on physical limitations, like if you don't have the supplies because the factory's shut down, or you can't get your employees on the job site. Economic limitations usually don't work in this doctrine. And then impracticality is another similar doctrine. It's not quite as high of a bar, but it's unfeasible, or it creates a substantial hardship to do in order to complete the work. There's another doctrine of frustration of purpose that is kind of similar, where you'll need to show that one of the principal purposes of the contract has been frustrated, that neither party is at fault, and that it's a substantial frustration, and the non-occurrence of the frustrating event was a basic assumption on which the contract was made. So hopefully some of these legal doctrines will help guide your thinking throughout this process. Is there any questions about any of these issues, force majeure, or any issues you're facing? If not, I'll kick it back over to you, Dana.
All right, thanks, Chris. if anything comes up and you run into a situation where you've got some issues, don't hesitate to give us a buzz or send a question to Dave, and we'll get an answer for you as soon as we can. The next thing I wanted to touch on is business interruption insurance. Like I said, it's going to be very specific to your policy, just like the stuff Chris went over. And legally, the language of the contract will control a force majeure type of an event, you know, acts of God and things like that, delays, changes, and so forth. Same thing with your insurance policies, because those are contracts. So whether you have any type of business interruption insurance and what it will cover is going to depend upon the language of your policy. So whether an epidemic, whether a government shutdown of work like this is a qualifying event for your insurance is going to depend on what your policy says. So that first bullet point, business interruption policies may cover civil authority losses from government mandated closure and things like that. You'd have to look at your contract and see what your contract says in order to know if that's what's going to trigger your ability to seek coverage under the policy. And then the other, obviously, is, okay, if a shelter-in-place order or an epidemic or, you know, whatever is going on, if that's a triggering event that will allow us to or cover potential losses from business interruption, then the next question is, well, then what losses are covered? And that's going to depend upon what your policy says too. If it's going to cover wage, it's going to cover profit, it's going to cover operational expenses at your office and things like that. You're just going to have to look at the policy. So so you got two steps. Is there a trigger? Is there an event that triggers coverage? And if you're covered, what's covered? So that's something that you're going to have to assess. Then the next type of insurance is that instead of a government or an epidemic being the source of the problem, that you have a supply chain problem. So this is the second bullet point, which is the contingent business interruption type of insurance. And so if you've got, if you can't get materials, then perhaps you have a policy that's going to cover something like that. So again, you go back and you look at the language of your policy and you see what it says. And then make a determination of what type of coverage you have. And once you know what events, once you know if you do have insurance that will cover an interruption in your business, then what are the triggering events and what is the scope of the coverage? And once you have that figured out, then you need to know what notices do you have to give, what information do you need to give to your insurer in order for them to cover the loss. Because one of the things that insurance companies like to do is collect premiums and deny claims. So if you have a claim that's covered under the language of the policy, but you don't tell your insurer in the way that you're supposed to tell them, or within the time frame that you're supposed to tell them, then that may disqualify you from receiving coverage. So they anticipate that they will be really strict with the way that they apply those timing requirements in your policies. There's a question that was posted in the chat that says, if a project is delayed by another subcontractor, framer, roofer, or concrete crew, what is our best protection to avoid liquidated damages? Step one is look at your subcontract. There's some, not all but often subcontracts will say that you have an obligation to notify the general contractor of any delay that's being caused by any other trade on the project. And usually if that's in the subcontract, then there's going to be a time period within which you have to give them that notice, usually somewhere between 2 days and 7 days. So the first step is to do that. Once you've given that information, then and you, if you're trying to avoid liquidated damages, then you don't just want to say, hey, I'm being slowed down by these guys, but you want to give them the detail of why. So the response that you're typically going to get back from the general contractor is, okay, well, if you can't do your work over there, then come over here and work here, or progress someplace else. So what you have to do is show where you're being impacted, how you're being impacted, and what that means to you in terms of time and of cost, and how that impacts the overall job, and then also everything that you're doing to mitigate. So if you're going to work someplace else on the job, then you go and you work there, but you want to tell the general contractor that you've switched and you're working someplace else, and that may have some efficiency impacts on you, because your plan was to progress through the project in a particular way, and now that you're having to split your forces on 2 different parts of the job, or do some other things in order to try and keep people working, that you're not going to be as efficient as you would be if you could do the job the way that you intended. So you want to make sure that you provide that level of detail to them, if possible. Obviously, definitely within the time that the subcontract says. If it's already occurred, so now the problem occurred, but you didn't go through and give notice about it, and you have the risk of liquidated damages coming back to you, then you have to go within your own daily reports and information and sort of recreate that, so that you're showing what happened, what you did to accommodate and to address it, and if that made you less efficient, why it made you less efficient, and send it back. So that's the information you give. It's best to give it as soon as possible, but if that didn't occur for any reason, go through and recreate it and send it to them now to avoid the risk of liquidated damages. All right. Like I mentioned, whether you're covered under business interruption insurance and whether or what's covered are the 2 big questions. So one is that you have to have some physical loss or damage, and your policy will define what physical loss or physical damage means. But as you can imagine, that's not an economic damage, so it's not a loss of income. It's a loss of or it's a loss to the project or to the business in some way because of some physical damage that occurred. And those types of losses really aren't construction related. Those are more focused on like perishable goods and stuff like that. When you talk about a physical loss, I haven't seen that exactly in the context of construction before. Sometimes the policy will require that your loss occur on the premises of your business. And so this next bullet point that talks about shelter in place orders would be that would focus more on the economic losses, because the premises, depending upon how the term premises is defined in the policy, that could be expenses and losses associated with the business at the home office. If premises is not narrowly defined, and there's the potential that premises could apply to job sites and things like that. So you have to look at the terms in the policy to see what fits within that scope. It's also not uncommon that you have exclusions. So the policy by itself will be written very broadly. And if you look at the scope of it, and if you look at the not just the scope of what will trigger it, but also what type of losses will be covered, it's written fairly broad. And then you get down in the policy and you get a list of exemptions or exclusions. And so you go and you look at those, and you may see that something like this, epidemics, pandemics, viruses, stuff like that, are excluded. And then the other thing is this concept of a period of restoration. So the period of restoration is, how do I explain this? So the idea of the period of restoration is the time period within which you have the opportunity to be able to resolve the problem on your own, more or less. And if you haven't, then that can limit your coverage. Then the last point is what I've been saying all along. They're different and you have to read them closely. Okay, Dave, that's everything that we've got as far as prepared information goes. We're happy to take questions from anybody who's on the call with what we've talked about here, or with, you know, other things that have come up and are going on with this whole virus situation. So if there's something that we didn't get into that people were expecting, and we can answer that question, we'll answer it on the call, or if we need to check on it, then we'll go check on it and get it answered too. But happy to take whatever questions people have.
Okay, do we have anybody that has a question for Dana? All right, just
I have a question.
please go ahead.
Okay. My question is, I have guys that have already been out, and they're coming back in a day or two after their 14-day quarantine. That was obviously before this has taken effect. And what happens in a week from now when they get sick and they need to be quarantined for another 14 days? Can they collect this money on their second 14 days because I never paid them on the first 14?
If they're being quarantined based upon a doctor's direction or on an order from the government that they quarantine, then on that second quarantine, yeah, you would have to pay them, as long as for that period that occurs on or after April 1st, regardless of what happened before.
So is there anything to prevent them from doing it over and over and over and over again?
Well, remember, they have to be, well, no, there's not, but you don't have to, you only have to pay them a maximum of 80 hours. So
Okay.
if the sick leave is just 80 hours, and the Family Medical Leave Act is providing care for children. So if they keep taking time off because they say that they're sick, and they're sick from this virus, then, you know, if they don't want to show up for work, they don't show up for work, but your obligation to them is only 80 hours of sick leave. And if they're saying that they're sick and they're not showing up because they're sick, that's only half of the requirement. The other part of it is that they have to be seeking medical diagnosis. So I got it on the screen here, the first one, they have to be symptomatic. So if they're if they're asking for leave because they say that they're sick, then they have to have the symptoms of this virus. And the other thing is that they must be seeking a medical diagnosis. And part of that is directed to avoid the problem that you're talking about, which is people wanting to just get paid for sitting around. So if you have somebody who says that that they're sick and they're not going to be coming into work because they think they have this virus, then the question you need to ask them is you need to say, okay, have you gone and taken a test? And if they say no, and they're not going to get a test, or they haven't called their doctor to get a test, then they're not seeking a medical diagnosis. And so you don't have to pay them.
And as far as their insurance, do I have to keep paying their insurance even though they're not here? Or can I add that as part of their 2/3 pay or their 100% pay? Can I add that into that portion of it?
Yeah, the benefits are the part that I've got to double check and get an answer on.
Oh, gotcha. Okay, thank you.
Any other questions?
Dave, this whole presentation will be on your website, won't it?
Yes, it will take an hour or so for it to get downloaded and processed. Yes, by the middle of this afternoon, it should be up on our YouTube channel, and I will make sure to send out an email with a link to it.
That'd be great. We're not experiencing any of these troubles right now, but a week from now, we sure could be.
Yeah, that's for sure.
Thanks, Dave.
What?
You're welcome.
Hey, there's
Any other questions?
Dave, there's a question in the chat that says this. There are safety requirements for face masks, gloves, and hand sanitizer provided by the employer, but we're unable to obtain these. We're concerned that by continuing to work employees without the safety items, we're putting our company at risk. How much should we be concerned about this? Well, you should be concerned that if one of your guys is sick and somebody else gets sick, that someone may try to bring that back to you. What I would do is, if the owner says that they're going to require that on the job site, but they want you to provide it and you can't get it, then you need to talk to the general and talk to the owner and let them know that you're trying to get that, but that it's not available for whatever reason. And then have them instruct you what they want you to do based upon that. The other thing is that if the owners are requiring it, then it should be at the owner's expense, especially the face masks, because what they're doing is they're creating, they're not expanding the scope of your work in the sense of what you're producing, but they're placing a personal protective equipment requirement on you that's not mandated by law, that wasn't foreseeable when you entered into the contract. So it is a change, and the owner should be paying for it. And if they think they can source it some way, then they should do that. So I would go back to the owner. I would go to the general contractor and the owner and say, this is what we've done to get it. That there's nothing within, double check those OSHA guidelines, but I don't think you're going to see it in there mean, I do think you will see stuff that talks about gloves, but not face masks. And so I would I'd submit a change order on it and tell the owner to source it if you can't get it.
Good questions. All right. Once again, this will be available on a recorded basis by the end of today. Once again, thank you very much, Dana, and your team, as well as Ashley and Dave Spatafor. We appreciate everyone's efforts. We'll continue to provide you resources as needed. If there are questions that you're having problems finding, please send them to me and I'll see if I can source that out. And please send me an email letting me know who has licenses and who's been watching or listening to this so I can make sure to give you CE credit. So be careful, stay safe, and stay healthy, everybody. Thanks.
Or do you want to come upstairs and play Jackrabbit with us?